Hello, hello. Here we are. It is just 7 o'clock Central Standard Time. I'm going to wait a couple minutes to dive into the subject, see if we can get any viewers. This is Amy Gramowski. I'm an attorney in Kansas City, Missouri. I represent people both in Kansas and Missouri. I have been a lawyer for over 20 years, and I have added estate planning to my practice. And so one of the traditional ways that you get estate planning clients is to hold these webinars and seminars. And we're actually going to be doing a seminar in person live at the Waldo Library next Tuesday. So if you are in Kansas City and want to come in person, we would love to have you. It's going to be very similar to this broadcast, but obviously live and in person. So the point of this broadcast is to give as much information as possible to people that are seeking out estate planning. We go a little bit deep, but for the most part, we're just going over the different topics. And then I would love for you to schedule a 45-minute free consultation where we talk about estate planning. We get you squared away on estate planning. And so anyway, so I'm still going to wait like one more minute, and then I'm going to dive into the topic. So I'm so glad you're here. Welcome so much. Welcome. And I'm excited to be talking about this subject. It is a subject near and dear to my heart. And so anyway, we'll just wait a little bit to see if we can get any viewers, probably wait one more minute, and then we'll dive in and we will get through the estate planning seminar together. I did one of these earlier today at 11. Now it was just recorded and we invited people to the Google Meet. And so we recorded it, which is great because it will give me some more things to use and to get better. And I'm going to be able to watch it and get better at giving this presentation. Okay, so I'm going to go ahead and get started. My name is Amy Gramowski. My firm is Amy the Attorney. I have been a Kansas City lawyer for my whole career. I graduated from the University of Missouri, Kansas City, and have started my firm in 2007 and have offered traffic ticket representation. So that's everything from speeding tickets to more complicated driving while suspended and driving under the influence. Now, I added, beginning in about 2020, at the beginning of the pandemic, I was having many people reach out to me. Many of my former clients reach out to me to see if I did estate planning. They were worried about, what was going to happen and powers of attorney, and for good reason. And at that point in time, I started to investigate, what I could do to add estate planning to estate planning to my practice. And so I've gone to a number of CLEs. I have an estate planning study group that I attend. I have read both lots and lots of material for the estate planning and trust in Kansas and Missouri. And I have kind of rolled it out in the last 6 months of having this service available. And one of the great things about estate planning is, well, first of all, with traffic tickets and with more complicated traffic violations, you're really meeting people in a situation where things are really dire and not great. And one of the things I am loving about estate planning practice is being able to educate people about what the process is. And nope, no, can you not see me? Oh, I want you to watch it on YouTube. This is my daughter, Katie. She's going to be our one viewer. She's going to get on YouTube. So anyway, so one of the things I like about estate planning is that it allows me to meet people and educate them about the process, about what happens, but it's when things are not terrible. Now, that's not to say that some people haven't come to me when things are terrible, they've gotten bad news and they need help with their documents. But this is these are people, my clients are people that are looking forward, wanting to make sure that what they want to see happen both during their life and after they die, willing to make the plans to execute those plans and let me help them execute those plans. And I really love that. Just the general tenor of the representation is different than criminal defense and traffic ticket defense. So anyway, that's a little bit about me. And I've taken on some estate planning clients. And what I'm going to do is I'm going to introduce you to a couple of families. And then we are going to go over 7 different topics, and I'll put on here what the topics are. I'll show you, we'll click through this. And the first one is wills versus trust. The second one are the key documents. The third one is probate court. The fourth one is protecting your heirs. The fifth one is nursing home concerns and solutions. The sixth one is powers of attorney. And then finally, end of life decisions. And so we will be viewing a lot of those topics through the lens of a couple of families. So let me introduce them to you. This is the Jones family, and the Jones family is a blended family, meaning this is a second marriage or second partnership between the two people. Mrs. Jones came with a daughter, and Mr. Jones came with 3 children of his own to the marriage. And it's sad to say that one of his daughters, Rachel, has been involved and is currently struggling with addiction issues. And of course, they are trying to pour in the love, trying to figure out what they can do to help Rachel. But this is also part of our planning and part of what they wanted me to know, because they're concerned that the assets they've gathered, Mr. and Mrs. Jones have gathered through their life, their house, their retirement savings, their brokerage funds, the whole gamut. And when they die, that Rachel would get a part of that as part of her being a beneficiary of the estate, but that it would further exacerbate her drug use and her addiction. So that is a concern of the Jones family. Now, in our scenario, the Jones family has gone to an estate planning attorney, has gotten the documents, and are ready to deal with this head on. Now, I'm going to introduce you to the Smith family. And this is a more traditional family. This is a family with first marriage for the mom and dad, and they have 2 kids under the age of 18. And I stress that they're over the age of 18, as opposed to the the Jones family. All of their children are above 18, but the Smith family has 2 children under the age of 18. And this is going to become important, because one of the documents that we would produce for you in estate planning is a will that would appoint a guardian for these 2 kiddos if the worst happened, and Titanic type situation, or a very terrible situation where both the parents died and the kids were left without the mom and dad. And of course, that is like dire situation, but it is a motivating factor for a lot of people to get estate planning done. My own personal journey as a parent is that we were foster parents to our 3 children. And then we were able to adopt them after 2 years. We walked into the estate planning attorney's office about a month later, because we just wanted to make sure that everything was taken care of. And in terms of if something terrible happened to us, and so that we could, that our wishes were known. But in our scenario, the Smith family did not go to an estate planning attorney and do not have the documents completed. So we're going to first dive into wills versus trust. And I would say that in our pop culture, in our parlance, in the way we speak to one another, and the way we see in the movies and the way we see in TV, is that it's a lot of it is about wills. I want to see the will. There was a recent series, Succession, where there was sort of a document, but it wasn't signed. It wasn't a legit will. But people were like, I want to see what's in the will. I want to see what's in the will. And so that has kind of changed, that we are not changed necessarily, but one of the tools in a estate planner's toolbox is a trust. And in many situations, the trust is the governing document, is the document that will be followed by the people, by your heirs after you die. And so the will is necessary, and we still will create a will in those situations, but it's called a pour over will. And basically, it's saying, hey, whatever we didn't get in the trust, we want to put that in the trust now. And we're, by our will, we're saying it's going to go in the trust. So the trust is an important document. Okay, so here, let me tell you about two different kinds of trust. There's a revocable trust and there's an irrevocable trust. And I want you to think about the trust as it's being a lockbox or being a treasure chest that you can open and close. And the revocable trust, in many cases, if you're the one that is putting, you're coming to me for estate planning, then you're putting things in the lockbox. You're putting your retirement account, you're putting the deed to your house, you're putting different investment vehicles into the lockbox. And in that case, you are the trustee. I'm sorry, you are the grantor. And then you would also, in many times, especially with a revocable trust, you will also serve as the trustee, the person that is in charge of the lockbox. And then there would be a trustee that is named in the trust for when you pass away. So this would be somebody that you trust, obviously, that you think would be able to do a good job of following through this process, making sure all the documents are filed where they need to be filed. A trustee could be doing income tax returns and probably will be doing an income tax return for the trust thereafter you pass away. So there are duties that are involved with being the successor trustee. So in the irrevocable trust, and what I like to do is have three people, basically usually the people that are granting the trust, the two people that are granting the trust, if it's a married couple, are the initial trustees, and then they would follow that up with a successor trustee and then another successor trustee. And the reason you would do that, obviously, is estate planning is planning for now. And so we would want to be having different people, different opportunities for people to serve, because when it comes to time, the person that is your successor trustee might be like, I don't know if I want to do that. So we would have somebody else be in the line so that they could then be the trustee. So that is, in many cases, that is what happens with the revocable trust. Now with the irrevocable trust, and we're going to get into this a little later about Medicaid planning, but basically an irrevocable trust is a trust, a lockbox. You're putting the same stuff in there, your house, your retirement savings, etc. You're closing the lockbox, so you're the grantor, you put everything in there. But in that case, you cannot be the trustee. Somebody else is the trustee. And that is while you are living, and that you have no control over what is in that irrevocable trust. Your trustee does. And what that does is it sets you up for being able to be Medicaid eligible if you need to go to a nursing home. So we're going to touch on that a little bit later. One more term that we're going to use with trust is the beneficiaries. And in common parlance, that might be heirs. So it's basically the people that you are going to benefit from the trust. All right. So we are going to go on to the next topic, and that is the key documents that we would produce in an estate for an estate plan. So it would go, first of all, we would have the will and the trust. And each, if it's a couple, each person gets a will, but there's usually only one trust. Now, sometimes there's a reason to have two trusts in each person's name, but for the most part, we would have one trust, and it would be the family trust. So, but in the case of the Jones, it would be likely that we would have two different trusts. Oh boy. That it would be likely that we would have two different trusts as part of that because of the blended family, because what Mrs. Jones wants to leave to her daughter and what Mr. Jones wants to leave to his three kiddos might be different, and they may want to differentiate between that. So the first thing would be two wills, a trust, and then we would be doing powers of attorney. And again, we're going to be talking about this a little more in depth later in the seminar, but there's two kinds of powers of attorney. There is the healthcare power of attorney, which allows somebody to make healthcare decisions on your behalf. So this is a document that is used while you are living. So many times estate planning, you think, oh, this will square away what we're going to do, what people are going to do when I die. But this is a document for when you are living. So the healthcare power of attorney allows somebody to make decisions on your behalf in the healthcare arena for decisions while you can't make them. So the second power of attorney that we draw up in estate planning is the financial power of attorney. And this is similar to the healthcare power of attorney, but it gives somebody the power to act on your behalf in finance when you can't act for yourself. So it may be something like they can do a trust, they can open a bank account, they can pay bills, they can collect your debts, they can do things for you that you can't do while you cannot make decisions for yourself. The next document is a HIPAA authorization, which allows you, whoever you grant that power to, the ability to get all of your medical records. This is obviously something, if you were in care and they needed some kind of document from a doctor or record from a doctor, this would allow the person you appointed, your loved one, to be able to get those records from the doctor. Then we will draw up a living will or a medical directive. And we're going to go a little bit more into this later on, but you think about the end of life decisions. And of course, I'm a Gen Xer, so Terry Schiavo played a big role in my view on this. In the early 2006, there was a dispute between a husband and her parents of a woman that was in a sustained coma of what should be done. And it was made national news. There was lots of things going on. But this is a way to avoid that situation by being very explicit about what you want to see happen if you were in certain situations: incurable disease, brain dead. And then the other thing that we'll address when we get to that section is life prolonging procedures. So those are the key documents that we will produce for you and your spouse or your partner if you come in that way. And we eat one of each. Those are personalized to you. We will go over what you want to see happen and make sure that that is in the documents. All right, the next section that we're going to talk about is probate court. And this harkens back a little bit to the Smith family, who have these two young children. And we have very sadly gone into a Titanic type situation where both the parents, Mr. and Mrs. Smith, have passed away. And so there are these two young children that need help and care. And like I said earlier, this is a good reason of why people come into why they come in and get these documents done, because they want to take care of this situation. However unlikely it might be, it is obviously, of course, something that can happen. And so when we talk about probate court, the Smiths family, so they're going to be dealing and reeling with the whole situation of Mr. and Mrs. Smith dying. So say their siblings, maybe their parents, obviously the kids, their close friends are going to be dealing with this sudden and terrible death. And because Mr. and Mrs. Smith have no will, then there is no appointed guardian. There is not a guardian appointed for these children. And so then it is going to be left to the judge in probate court. And obviously somebody that, and the first let me say about probate court, they are the nicest people ever. There's a probate court. If you're in Kansas, it's in the district court. If you're in Missouri, it's in the circuit court. Every court either has a judge or a division of judges dedicated to probate. They are the people that deal with contested wills, guardianships, conservatorships. They deal with people that didn't have a trust, and so their assets need to go through probate. But so when we're going to talk specifically about the Smith situation. They did not have a will appointing a guardian, because that is one of the things that you would have in your will, is you would be appointing a guardian for the people under the age of 18, your kiddos under the age of 18. And so a judge is going to be deciding who these children should live with. Now, like I said, they're great people. They have hearts of gold in probate court, because they're obviously dealing with people that are going through grief. But this is not a situation you would want to be put in. You would not want to put your loved ones in this situation, because then your will is not being done. And it's tough, because you are sitting there, with your spouse or maybe by yourself, trying to decide, well, who would be the right guardian? And in our situation, none of my siblings live in Kansas City. But my husband's, they do live in Kansas City. He has several siblings that live here. And so we have to kind of decide what is going to, when we were deciding who is going to be the best situation for these kids if the worst happened and we were both gone. And, we decided to somebody that was in town, my in-laws that are in town, and could help and take care of these kids. And, we had a conversation with them about it. But the Smiths haven't done that. And so a judge is going to decide. So in addition to, this terrible loss, grieving, and having to deal with that, the whole thing, they are now going to leave the fate of these children and the fate of, Mr. and Mrs. Smith's finances, whatever they may be, to a judge, to somebody that is not known to them. And what I have heard from people that are dealing with probate is, you don't know until you know how terrible it is. And like I said, the probate court is a great place to be in terms of accessibility and the kindness, but it is a difficult, place to maneuver, and you would be leaving them with attorney fees and uncertainty when you can get it all wrapped up. And so this is a little bit of a scare tactic in a way. I don't mean it to be, but you really do not know about probate until you are in it and realize the hurdles that you would have to jump through to get access to your loved one's money, again, with the kids, in terms of who the guardian is. So these are things that can be avoided with the proper estate planning. Probate court can be avoided. So now we are going to talk a little bit about protecting your heirs, and we're going to get back to the Jones family and their daughter, who has issues with substance abuse. Now, we know that this is absolutely a possibility, and there could be all kinds of different addiction issues that could be going on. There could be gambling, there could be drugs, there could be lots of addictions going on. And you would want to protect that person. And when you pass away, that you're not doing anything to exacerbate their addiction. So in a trust, you could have your trustee be the person that decides when Heather, the person that's has this um, debilitating disease of addiction, of when she would be eligible to get money from the trust. And it could be a standard that you put in there. It could be up to the trustee's best decision. But there are ways to safeguard that so that you feel like you're walking away with a situation where the child is taken care of, or the adult child, and that by coming into a sum of money, they are not going to exacerbate their addiction. This also goes for anybody, teens, tweens, young adults. You can do what is called a rainfall, where basically your heirs would be taking part of the money while you at a certain age. So say, you're coming up with your estate planning, your kids are 19 and 21. Well, if you pass away and they would get that money, imagine a 19-year-old or a 21-year-old, coming into $100,000 or $150,000, and the decision making and their decision making brain about that would be incredibly difficult for them to make the right decisions. And so we can write into the trust that they would receive that money based on an age, and or the trustee's discretion. But so say we say our kids are not eligible to get our money or to get their inheritance. They get a fourth of it when they're 25, and they get, 3/4 of it when they're 30. Well, you think about the decision-making brain of a 19-year-old versus a 30-year-old with an amount, anything I would say over $50,000 is a life-changing amount, could be a life-changing amount for somebody. And why lead them into temptation to have this amount of money when they aren't really thinking about their future, thinking about a down payment, thinking about what they need to do with that kind of money? So that is a way that you can protect your heirs, and we do that through the trust. So the next topic we're going to be talking about, and I'm going to just take a small sip of water and check the time. I've been talking now for 30 minutes. Are nursing home concerns and solutions. Now, first off the bat, I want to tell you, this is elder law. This is not estate planning. If you came to me with this issue, I would refer you to an elder law attorney, somebody that does this work in specifically, because it is a delicate and complicated area of the law. I have studied it. I have been to boot camp about it. I've been to numerous continuing legal education seminars about it, and I still don't touch it because it is so complicated. But what this is doing, and when we were talking about the irrevocable trust, so you're putting all the stuff into the lockbox, you're locking the box, and then you're putting somebody else in charge of it. And the reason you would want to do this, one of the reasons you would want to do this, is that if you or your spouse had to go into a nursing home, we would lock up those assets. It gets a 5-year running total started on it, so that you would, that basically after 5 years, whatever is in that trust wouldn't be touchable by the government. Once you have been in the nursing home and passed away, they would come back with a lien. It would also help you to become eligible for Medicaid, so that the nursing home would be paid for. And when we're talking about nursing homes, we're talking about homes that cost, $6,000, $8,000, even more per month. Obviously, specialized care for some people with Alzheimer's and dementia, some other afflictions that affect people of an older age. And so basically, we want to get that into a lockbox, but that it's guarded by somebody else besides you. And that is the key to an irrevocable trust. Now, there is another kind of Medicaid planning. So that is Medicaid planning. And then there is called crisis planning. And crisis planning is when, hey, grandma is going to the nursing home next week. We are trying to figure out how to pay for it, how to not lose the family farm in it. And the crisis planning, again, done by an elder law lawyer, would be then looking at the whole estate, trying to figure out how they can chop and, dice and chop and dice the estate so that the government can't come in and take that money and take that, that estate. So that is emergency Medicaid planning, even though it doesn't sound like emergency Medicaid planning. Seems a little, emergency and planning aren't exactly the same word. So, but again, an elder law lawyer, if you have an issue like this, I would love to give you a great referral for an elder law lawyer. There's plenty in Kansas City. Not plenty, I shouldn't say that, because honestly, it is an area of law that is so complicated that people would need, you would definitely want to have somebody that has done it before. Okay, so now we're going to talk about powers of attorney, which I feel like are the superheroes of all the estate planning documents. They can do a lot of heavy lifting for the people. And so powers of attorney are meant to be used while you are living. And so there's a couple considerations. So I talked about the two different kinds of powers of attorney, medical and financial. And another one of the decisions that we would make together is whether that power started right away on the date you sign the documents, or if that power starts and it's called when you become disabled. So whatever that event may be, that is called a springing power of attorney. And that is, so that would be something where two doctors agree, you are not able to speak for yourself, and then the powers of attorney come in, and the person you've appointed to be the power of attorney would be able to make decisions. Now, I'm an advocate for making the power of attorney good right when you walk out the door. If you're going to entrust this person with decisions for your finances and your health care, I would say you would hopefully have picked somebody from the start that you trust, and they would be able to use it right away. Another decision that we make together is who is going to be the power of attorney for finances and medical, because it might not be the same person. And many times it's the spouse. That would make a logical solution. But then I always want to come up with number 2 and number 3. Who are those people? Is it a sister? Is it a sibling? Is it a parent? Is it a child? Who is going to be making those decisions for you and with you? All right. So those are the decisions that we would be making in powers of attorney. Lastly, we're going to be talking about end-of-life decisions. And this is obviously a situation that everybody's going to have to endure. We're all going to die. And it would be better to have some of those decisions laid out to your family, to the world at large, which is what a medical directive is, a living will is a notice to the world of, hey, I want to see these things happen. And it can be, anything can be in that medical, in the healthcare, in the medical directive, the living will. But further on than that, that is something that you would want to be talking about with your spouse, your loved one, your powers of attorney, your trusted people, of really what you would want to see happen if they are indeed in a situation where they're permanently brain dead, if they have an incurable disease. What do they want to see happen? There is a great book called Being Mortal by Antui Grande. It's highly recommended reading. I'm just totally love that book. But he sort of explores that idea along with detailing his father's life in America and also his death and sort of what his father said that he wanted to see happen. And I believe they were both doctors. So they kind of had seen, they had experienced some of the things that can happen. And one of the facts of the book is 60 years ago, most people died in their homes, but now most people die in a hospital. And sort of, is that really what you want to see happen? And so you should be talking about these with your loved ones, with your people, and then we can also write it down. One of the things that I love that I've seen is in my chart. You can upload your medical directives so that they have it in there. But this can be a living document. And it was so important for your loved ones to be able to act on your behalf if you cannot act. And this is, near and dear to me. My dad was had a heart attack and was hospitalized. And the doctors were very clear from the start that it would be that it was like when my dad had a heart attack, that it was like he had been submerged underwater for 20 minutes. I mean, that's the visual they gave us. And so it does make sense that this would be something that he was not going to survive. And, this was in 2005. And I do feel like there have been advancements in hospice and palliative care, end of life care. But at that time, we really felt very out there. The hospital is not used to people dying. That's not why they're in business. And they didn't quite know what to do with us. They wanted us to be out of the ICU, and went with him to a regular bed in the hospital. But of course, it wasn't a wing of palliative care. They didn't really know what to do with us either. We ended up calling Kansas City Hospice. My sister I don't know how she got the idea, and they came in and kind of helped us through that end of life and sort of what to expect. But I will tell you that my mother was very clear about what my dad wanted to see happen. It was never any doubt that, we were going to let nature take its course and that we were going to be taking him off the machines. It was incredibly difficult and sad and just the worst. But she didn't have any doubt about what he wanted. And I am so grateful for that we didn't feel like he was in pain, and that he could end, the end of his life could be as peaceful as it could be in the hospital after a heart attack. So this is something, in addition to the documents that we would create for you, that I would create for you, this is something you should be talking about with your loved ones. And I know it's tough. I get it, but it's it's going to happen. There's no doubt about it. So anyway, on that light note, I would love it if you would call and schedule a estate planning consultation with me. We will talk for about 45 minutes to an hour. I can do it on the, I'm trying to figure out how to stop the share screen. We can do it online in a Zoom or a Google Meet. We can do it on a in person. I'm happy to do that as well. We'll go over all of these questions, all of these documents. I give you a little bit of homework to do before you come to the estate planning consultation, but nothing big. We want to make that so that it's low entry. It's like, hey, Amy, I want to get my stuff done. All right, here's some questions I have for you, but let's just do it all together right now, and we'll all be asking the questions. So I would love it if you would schedule the consultation. I am so glad that you are visiting my webinar. Thank you so much from the bottom of my heart. It means a lot to me as I enter this new practice and add this practice to my firm. I am just excited, and it does sound a little weird because you are talking about death, but I am excited to help people, because that is why I went to law school, was always to help people. I always had it in my heart that that's what I wanted to do. I was a social worker before I was a lawyer. And I've somewhat continued that path on being a lawyer in that I'm helping people. I would love to help you. So please give us a call or visit my website. My calendar is on my website. You can make an appointment without even having to call anybody. All right. Thank you so much for watching, and we'll talk soon. Bye.